In this episode, we will review 3 different probable cause hearings held in the courtroom of Judge David Fletcher of the Harris County Criminal Court in Houston, Texas. A probable cause hearing is a proceeding that takes place soon after a person has been arrested, especially when the arrest was made without a warrant. Under Article 15.17 of the Texas Code of Criminal Procedure, the arrested individual must be taken before a judge without unnecessary delay. At this appearance, the judge informs the defendant of their rights and reviews the facts presented by law enforcement to determine whether there is probable cause to believe that the individual committed the offense. If the judge finds that probable cause did not exist for the arrest, the defendant must be released. Our first probable cause hearing took place on the 4th of November 2024 after defendant Raquel Rodriguez was charged with driving while intoxicated on the 28th of October 2024.
Yes.
Okay, Max, who do you have here?
Raquel Rodriguez.
Rodriguez. Vic, you ready? Okay, this is page 20.
Rodriguez on page 25.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65 mile per hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
While the SFSTs were, this is for the Jams, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk-in turn, the one-leg stand. He also noticed that I think she took off her boots for the one-leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, just an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accent here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her. I mean, which is per, you know,
But
procedure for
right,
SFSTs,
I get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 in the morning, and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
Alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Thanks, Judge.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button, you have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
Right, please take a seat.
Judge Fleer finds no probable cause for the charge because he did not believe there were sufficient indicia of intoxication to authorize so-called SFSTs or standard field sobriety testing. Because field sobriety testing extends the duration of a traffic stop, resulting in a longer investigative detention, officers must have reasonable suspicion that a driver has committed an intoxication offense in order to require field sobriety testing. Here, the evidence was limited to the smell of alcohol. and Miss Rodriguez's statement that she had consumed 2 drinks, the last of which she had finished 2 hours before driving. Accordingly, Judge Fleer determined that there was no reasonable suspicion to extend the traffic stop to perform field sobriety testing under state and federal case law, as well as Article 38.23 of the Texas Code of Criminal Procedure. Evidence that a police officer obtains through a constitutional violation, such as extending a traffic stop without reasonable suspicion, cannot be admitted into evidence against the accused in a criminal case. Therefore, because the results of the field sobriety testing could not be considered, Judge Fleer concluded that there was no probable cause for the arrest, and the state eventually dismissed the charge on February 24, 2025. The next probable cause hearing we will review also occurred on the 4th of November 2024. Defendant Keon Shaw was charged on the 28th of October 2024 with fleeing a police officer in violation of Section 545-421 of the Texas Transportation Code, which makes it a misdemeanor offense for a driver to willfully fail or refuse to bring their vehicle to a stop when given a visual or audible signal by a pursuing police vehicle.